This is Rhonda Souter. I'm reporting live at the Supreme Court of the United States. We're awaiting the decision on the case Brown v. Entertainment Merchants Association. This case asks whether a state law restricting the sale of violent video games to minors violates the First Amendment right to free speech. While we're waiting for the answer, let's look at a brief history of the video game industry. In 1971, we saw the first arcade video game released. And in 1976, Death Race was pulled off the store shelves for being too violent. In 1993, Mortal Kombat was scrutinized by Congress and would have been pulled off the shelf just like Death Race, except it was given an Entertainment Software Rating Board's rating. The ESRB is a self-regulatory organization that assigned age and content ratings to video games. This rating system, however, is strictly voluntary. However, nearly all video games are submitted for rating because many retail stores prohibit the sale of an unrated video game, and major console manufacturers will not license games for their systems unless they carry the ESRB rating. In 1997, we saw one of the first video game lawsuits brought about by Jack Thompson. This was largely in fault, saying that lawsuits claimed video games were responsible for violence perpetrated by teens. Adding to the controversy was Grand Theft Auto, and increasing panic was the Columbine shootings in 1999. In 2000, Indianapolis tried to enact ordinance limiting minors' access to violent video games. However, this was struck down by the Seventh Circuit Court of Appeals. The Surgeon General in 2001 found little correlation between the media and violence, saying the highest risk factors for school shootings center on the mental stability and the quality of home life, not the media exposure. Starting in the 2000s here, we see state laws starting to be struck down for unconstitutionality. Few of the states were Illinois, Michigan, and Louisiana. These games were labeled as restricted to adults only and required retailers to post signs explaining the industry rating systems. However, they couldn't ban the game selling of these to minors. So in order to save money, the Supreme Court agreed in 2010 to decide the constitutionality of the video game statute. And it looks like they made a decision. And the question to whether the violent video games selling to minors violates the First Amendment right to free speech is yes. The court found that there is no compelling evidence to state that video games are more damaging to children than other forms of media, and that it should be protected as an art form. Well, this is news indeed. So let's take it out there to our reporters out there waiting to interview our crowd, and let's see what they have to say and what their opinions are. Take it away, guys.